This section B question is all about breach of contract and remedies. So we've got here AZ Limited operates a shipbuilding business which specialises in constructing and modifying ships to order. So these are bespoke pieces of work. In 2011, they entered into an agreement with Bob to completely rebuild a ship for a price of £7 million. Now, the problem is, once the work was done, Bob informs AZ that he no longer needed the ship. So Bob doesn't want to pay, doesn't want the ship anymore. AZ had already spent £5 million on altering the ship, so that's its costs. And so they're now starting an action against Bob for breach of contract. Now, just before the case was due to be decided, AZ sold the ship for the same amount of money that they would have received from Bob. So we've now got 3 questions to consider here. Task 1 asks you, which 2 of the following statements explain the purposes of awarding damages for breach of contract? Well, let's be clear on this. The action that is being taken for breach of contract is a civil case. And the role of a civil case is to compensate somebody who has suffered loss. And we contrast that with the criminal case, which is there to punish the wrongdoer. So which 2 of the following statements are relevant here in terms of damages for breach of contract? So the first thing that these damages do is they compensate the injured party for their financial loss. So it's recognising financial loss. Of course, financial loss, the reason that that's focused on is because it can be quantified. And you may remember from some of your other studies or research that actually when you start trying to compensate people for things like loss of enjoyment, it very quickly becomes very messy. So as a general rule, damages are there to compensate specifically for financial loss. And the key to this as well is that they are designed to put the parties in the position they would have been in had the contract been performed. Now that is very different to putting people back in the position they were in before the contract was formed. So here's a practical piece of advice for you. If you ever buy something from a shop and it causes you problems, you know, it's not working or whatever, and you go back and the person behind the counter says, well, I'll give you a refund. Well, you have the right to accept that refund, but you also have the right to be put in the position you would have been in had the contract been performed. In other words, to get a replacement product, a reasonable replacement. We've established that because this is a civil and not a criminal case, we are not looking to punish the party. Now, there are some legislative areas, for example, in the United States, there is this concept of punitive damages, where the wrongdoer, the person who has breached, is punished in order to deter other people from committing a similar breach. Now, that is not consistent with the English legal system. It happens in very, very rare exceptions. But generally, the objective with any civil case, and specifically here with contract law, is we put the parties in the position they would have been in had the contract been performed. And we make up for any financial loss that they've incurred that hasn't got them to that position. Task 2 asks which two of the following statements in relation to the duty to mitigate losses are correct. Well, the person who has suffered the loss is the claimant. And in terms of mitigating that loss, reducing that loss, therefore it is the claimant, the party who suffers the breach, that would look to mitigate their losses. What does that do? It will therefore reduce the damages that are payable. So this whole idea of mitigated losses is to get away from a situation where a claimant has a valid case, but then deliberately manufactures a situation where the losses pile up. So claimants have a duty to reasonably mitigate their losses. The third and final task for this question: what level of damages can AZ claim for breach of contract? Well, remember from task 1, we said that they can claim for their actual financial loss. So if the contract had been properly performed, they would have received £7 million from Bob. Now, Bob didn't pay them £7 million. They took legal action. However, what's now happened just before the case is due to be decided, then they've sold the ship for the same amount of money that they would have received from Bob. In other words, they've received £7 million, but from someone else. Therefore, AZ has actually made no loss. The only difference here is that they sold the ship to somebody other than Bob. But in terms of the cash flows, they've received exactly the same cash flows. Therefore, their financial losses are nil. And so if this case did go to court, chances are that Bob would be found liable for breach of contract, and the damages would probably be nominal damages of £1. In other words, recognition that yes, you were in breach of contract, but in terms of the loss suffered, it is non-existent.